Hello, everybody. Welcome back to another session of the Real Estate Lawyers Corner. I'm Scott, a local real estate agent here in San Diego. Eric, why don't you introduce yourself?
Hello, Scott. Yes, I'm Eric Ching. I'm an attorney here at Ching and Seto. Thank you for having me again.
Yeah, and he is an attorney here for the state of California. So he's licensed in
Oh
the
yeah,
state of
I'm
California.
licensed in California. I'm not licensed in any other state.
Yeah, correct. And so we have our new little disclaimer banner up there that is here to protect my friend Eric, because we're going to talk
Yeah.
about something that's really important. That I'm seeing this happen a lot more, and it's starting to affect individuals because I see a lot of chat about it online. I don't know if that's true for you, Eric. Are you seeing this? Because we're talking about divorce, right? So when you buy a home in a divorce situation, or even if, let's say, you're just in a partner relationship and you buy a home with another person, and let's say that relationship doesn't go well, and then now you guys are parting ways, like, what happens? I mean, what is it that people, what are their choices, what are the things like that? So Eric, I'm going to play a couple of videos, and then I'm going to let you watch it, and I want to talk to you about it. Sound good?
Sounds good.
All right, so let's, first video is,
are you going through a divorce in Colorado and that house is feeling like more of a burden than a happy memory? You might be wondering if you can sell it before everything is finalized. Don't worry.
so now for the audience, we have obviously people watching all over the country. And the thing is this particular situation is about, in Colorado law. So every state will be slightly different. We're going to play a little bit of this clip, and then we'll go from there.
Divorce is still chugging through the legal system. And can you actually sell the house before the judge slams the gavel and finalizes everything? Well, in Colorado, like most things involving law, the answer is a bit of a maybe. And here's the twist. When you file for divorce in Colorado, an automatic injunction kicks in. This fancy legal term basically means that neither spouse can get rid of the marital property, like your house, without the other's okay or a court order. So selling the
Okay, so going back to this, Eric, is that also the case for California and most states?
Pretty much, yeah. You selling up, and the answer that he's given is it depends, right? That's the answer. That's also I will also get it. It depends, right? You know, we there are divorce cases where the spouses both have agreed that we're going to sell this house and we're going to split the proceeds, right? And they come to that agreement, and that's fine. There's nothing wrong with that, and they can definitely sell the house before the divorce is finalized and split the proceeds, right? There are also other cases where it's a pretty contentious divorce, and there's disagreements on how proceeds are supposed to be split, right? In which case, you're not going to get both spouses agreeing to sell the property until there is a final figure on how the equity is going to be split, right? So it really just depends on the stage of the divorce and whether the parties that's divorcing can get on the same page on how to split the money from the real estate sale.
Okay. And that's a pretty normal expectation, right? But there isn't a lot of divorces that are not contentious. There are some, obviously, but what happens if, let's say, not all divorces go into a trial, right? So there could be mediation, there could be a bunch of other things that could theoretically happen
Hmm.
during the divorce, and there are
Right.
people that do
So
their own divorces.
yeah, absolutely. Like I said, there are divorces that are not as contentious, right? You don't have kids, you don't really have everyone agrees, let's just split, whatever pot of money 50-50. In which case, great. It's called a MSA, marital settlement agreement. Put it together, we'll sell the house, split the asset 50-50, right? In
But
which
how
case
often
there's
does
no
that really
trial, there's
happen?
really nothing. Huh?
How often does that really happen though? Probably not as frequently. I
No,
would say, I
actually,
would think the other extreme
it's
would
a
be more frequent.
misconception that all divorces have to be contentious.
Okay.
Okay. If everyone is on the same page, look, this marriage is not working, I just want, 50% of the equity. I'm not going to nickel and dime you. Oh, I pay the mortgage this, and you didn't pay the property tax this year, then, I've seen a lot of divorces where people do it themselves because they are able to come to a resolution by themselves,
Okay.
right? That's perfectly fine. Then there are those that really, there's child custody issues, there's, visitation rights issues, that gets lumped into, well, because you get the kid more, now I want more of the money from the sale of the house. There is an emotional component to a
Yeah.
divorce, and which is why most often people see divorce as a very contentious type of process, when in
Yeah.
fact, I have seen if everyone's on the same page and we're all in agreement on how to resolve this, then it's just hammering out some terms and getting it finalized, right?
Yeah.
So it really doesn't have to be contentious, and in fact, selling a property when it's not contentious is much easier when you're trying to force someone to sell a house when they're not happy about selling the house, right?
Yeah.
Um,
So
so
I'm gonna play this video because this is actually another attorney in a different state, and she is talking about she does this game called How Much, and so I actually thought it was kind of funny, so I'm gonna play it real quick just to show it to you guys.
Playing They Got How Much. We have a couple that got married, and 3 months later they decided that divorce was the best choice for them. However, they have been together for 3 years prior and together have purchased a condo. The condo is in the husband's name. My client is the husband. How much should he get? Well, in this case, the condo is not truly a marital asset. The condo was purchased before they were married and is solely in his name. So the wife, through her attorney, can argue that there is a marital interest in the property, and there may be monies due to the wife depending upon whether or not he used marital funds to pay down the mortgage. But ultimately, he should get the home.
So do you agree with this?
Absolutely. I agree with that analysis. And I'll explain a concept to your viewers, something called community property and separate property. The general rule is any assets you acquire before you are married is considered separate property. That means in a divorce, separate property is by default to you only. Assets bought and accumulated during the marriage is considered community property. By default, in a divorce, it's split 50-50. Okay. And there's modifications that depending if they have a prenup or a postnup. Okay. So that's what the video was talking about, because this condo was purchased as a separate property. It's in the husband's own name. Okay. In a divorce, legally, he would be entitled to that property. Now, the video did mention something about mortgage payments. There's a concept in California where even though a property was acquired before marriage, if the community property, like the income after marriage, was generated to use to pay for the mortgage of that property, there could give rise to claims that it becomes a community property asset, or a portion of it becomes community property, or it does give the other spouse some sort of claim to this condo or this real estate asset. Okay, so the only way to prevent something from happening is, one, either you have great accounting and can prove that only separate property, i.e., your own income or own savings that you had prior to marriage, which is separate property, was used to pay for the mortgage, which most people, that's not the case. The
No.
only other way is to really have a prenup to really specify, all right, in the event of a divorce, this property is going to be mine, regardless if community property was used to pay the mortgage or the property taxes or any other expenses related to this property.
Yeah,
Okay.
and I find that I'm speaking out of place, but I would think that when I got married, I didn't sign a prenup, right? So I would assume that most people that's gonna be the case because my thought was prenups are for rich people. I'm not a rich person,
No.
so look at the lawyer shake his head.
That's a
Um,
that's a very prenups don't need attorneys involved. There's a lot of these programs out there that what prenups are really going to be beneficial is when both spouses are coming into marriage with assets. If you're broke, that doesn't matter, right? Because you have no assets anyways, right? But if one spouse has their own property and the other spouse has their own property also, it would be a good idea to at least get a prenup discussing, all right, in the event of divorce, these houses just go back to each respective owner, right? As if it was before the marriage, right?
so let me ask you this.
Um,
Let me play. I'm gonna make your life difficult, Eric. All right, for a second.
okay.
Let's go back to that scenario of that individual. Husband owned the house 3 years before, right? They just got married, 3 months, they're filing for divorce, right? Let's assume that there was a clear separation of marital personal assets to pay for that property, or whether or not there isn't. But the thing is if let's hypothetically pretend that the wife helped pay into the mortgage, and the thing is now she moved into the property and she lived there, right? The husband could theoretically argue, well, you didn't pay me rent.
No, you're married.
So correct. So, but the thing is whether or not, like, her lawyer could make the argument that says, look, we use marital funds to put into this property. She deserves the right to have that property as well.
Correct.
But then the husband's like, well, we only use marital funds because you lived in it.
No, it's just by default, it would be anything, any mortgage payments. So any income you derive after you marry is considered community property. So the income you use between you and your spouse that goes towards paying this mortgage that you acquired before marriage, okay, is considered using community property to pay for a separate property, which means that now, while it's only been 3 months that you've been married, all right, technically there is that 3 months period that could give rise to saying this other spouse saying I have some ownership. It's not going to be a lot, all right, because it's you only been married for 3 months, but potentially there is that claim. Most likely in that scenario, the court will just say, look, it's been 3 months marriage. It really doesn't make that much of a difference. This is still going to be separate property, right? Now,
Okay.
if the length of time was extended, let's say, this property was acquired 3 years before they married, but they've been married for 10 years, all right? And during this entire 10 years, right, community property was used to pay the mortgage, right? Every single month, every single year. That spouse that technically is separate property can give a good solid legal argument that for that 10 years that property has appreciated, and that equity, all right, is the spouse's.
Up for fair game.
Yeah, exactly. It's community
It's fair
property,
game to be
right?
split, right?
It's fair game to be split. So
So
that's
how does this
just how it is in divorce law and these type of things related to real estate.
and there is, I guess there is no, you have to go to court, but the thing is there's no precedence. I'm asking questions that you may not have the answer to, but there's got to be precedence that says, where's the cutoff point, right? When is it prorated and when is it 50-50? Is it 4 years?
Oh,
Is
it's
it 5
very
years?
situational. It's very situational, which is why these type of things can get very contentious on how to split real estate when it comes to a divorce. But the default rule is marital assets is going to be split 50-50, regardless if someone put in more money, regardless of who paid the mortgage, because at that time, once you get married, and you have to understand this, any income you derive after you marry is considered community property. There's
Yeah.
the only things that are actually considered separate property is assets you accumulated before marriage, assets that you inherited or gifted. All right. Those
The
are the,
thing though
so
is you
unless
still have
you
to put
use
that into a
inheritance,
prenup.
well, yeah, or put into a prenup to really distinguish out, all right, in the event of a divorce, what is going to be considered separate property versus
Yeah.
community property, right?
Okay.
Most prenups are there to protect assets that are premarital, not necessarily during them, because during marriage, you don't know what you're accumulating. You don't know what assets you have, right?
Yeah.
So usually prenups are there to protect those. And I guess you can consider someone that has a house before they married considered wealthy, right? But yeah, but if you have a property or substantial wealth, it is a good idea to have a prenup, all right, just so that you know that those assets are going to be protected even in the event of a divorce. Otherwise, there could be your spouse could claim 50% of that.
Yeah. And not just houses, but like if you own a business, for example, guys, right? That's really important because I mean, if marital funds go into supporting that business that you run, you know, when you if in the event of a divorce, that becomes problematic because now you're gonna have to like you know, potentially you have your spouse that owns a portion of that business too. Would you agree?
Yes, yes. That gets into a whole other can of worms. Yes. Theoretically, if you're putting community property funds investing into your business or whatnot, there could be a claim to a part ownership of the business by the spouse. Most of
Yeah.
the time, you would sign, your spouse would sign over any rights to any ownership in the business. And if you're a business partner, it would be a good idea to get your other business partner to do something like that. So
Yeah.
the ownership of this company isn't subject to a divorce, right?
Yeah. And so there's so
Um,
much complications in this that there's no way anyone's going to know the answer. So like if you are thinking about buying a property with somebody that you're married to or not married to, you really should talk to an attorney. I mean, you really should just absolutely discuss it with an attorney that you pay
yeah,
for
right,
because they're going to be able to at least give you a bigger picture of all the potential issues.
right. And to add to that, look, most of the time, now, I want to be very frank with the viewers. I'm not a divorce attorney. I do not do family law. I get brought into divorce cases because of either real estate disputes or they're trying to figure out how to resolve a real estate dispute. Okay.
Correct.
Because how you structure it can impact whether or not your property taxes increase or if there's any other type of capital gains or tax implications. Okay. And so, what people have to understand, the divorce process usually ends up in something called a marital settlement agreement, where both parties have now discussed and figured out, how to split these assets, right? Real estate in a divorce usually majority of the time does end up with the property being sold. And that's what viewers have to understand. It's not because the parties want it. It's mainly because of the financial situation that the parties are in. Okay. The properties are sold because, again, for one spouse, let's say one spouse says, I want to take ownership of this property. The other spouse is going to say, it's fine, take ownership of the property. But that means you also have to take over the mortgage payments or refinance it so that my name is off this mortgage. All right. The other spouse, most likely, unless they also make a lot of money, is unable to probably financially sustain a mortgage by themselves. Okay. There might be, alimony or something like that, but it's really income specific related to that. Okay. But the most common situation is one spouse is unable to financially front, paying for a house, especially in California where houses are very expensive. Right. And ultimately that's left with, the property having to be sold. Right. The other alternative, which happens less, is a buyout, right? The other spouse who wants the ownership of it will buy out the other one. Say, hey, there's an equity portion of $50,000. I will pay you $50,000, buy you out of your ownership 50% ownership of this property, right? But there's another challenge to that is the loan on it. Okay, just because someone relinquishes ownership of the property to the other spouse does not mean now that other spouse that no longer owns the property has no obligation under the loan. Okay,
Yeah, you
a
signed the
divorce
promissory
doesn't.
note when you bought it, right?
Correct. You are still you are still a borrower from the lender's perspective. A divorce doesn't say, oh, now I don't have to pay the mortgage. Okay. And so what I've seen a lot of mistakes happen is, all right, one spouse gives, the ownership to the other spouse, but they never refinance the loan. What that means is now the spouse has no ownership in property, but still owes on the mortgage. Okay.
Yep.
So anytime that spouse decides to either do a credit check or, maybe apply for a loan, that will show up as still a debt under his or her name.
Yeah.
Okay.
And that could
And
theoretically also prevent them from qualifying to buy another house because now they're
qualifying for buying another house, right? And
Correct.
so the only way to solve that is refinance. Now, when interest rates were so low, refinancing was no problem. What I've been getting a lot of calls when people are in this situation is like, well, I don't want to refinance because interest rates are now a lot higher. Okay. Well, then you have to know that if you agree to giving up ownership in this property, you are still responsible for the mortgage. Okay. That means if your other spouse that you divorced from stops paying on the mortgage, defaults on the mortgage, files bankruptcy or whatnot, look, you're impacted by it too, because the bank says, well, you owe the money.
Yeah,
okay.
Absolutely.
So, I've seen a lot of these divorces where, divorce attorneys will help their clients, but they don't really see the implications on the real estate side, on really the practical implications of what they're doing, right? It's easy enough to say, oh, I just take the house, right? But there's a lender that's oftentimes that is a big hurdle. That's why most divorces that I've seen does end up with the property being sold. Okay.
Yeah. Yeah. That's a very valid point because a lot of times divorce attorneys are family law. And so because they practice family law so much, they may or may not be completely aware of the real estate side and how title was taken and whether or not this person signed a promissory note when they purchased this property with their spouse. Yeah,
Right.
Those are all very, very important things because you might think that it's not a big deal when you're like, oh, we're getting a divorce. We're both, amicable. And I want to play nice and I'm just going to be okay leaving my name there because interest rate is when we bought this house was at 3%. And if he had to refinance, it's going to go to 6%. So we're just going to leave it. There is potential issues and liability there for the person who is volunteering to stay on that debt because it will affect your credit score. It'll affect your credit rating, everything.
To give people some perspective, it's a 30-year fixed term loan. Your name is, unless it's refinanced, is on that loan for the next 30 years with the person you just divorced from. All right. Yeah. Anything can happen for the next 30 years. So when I see stuff like this, I basically, and a divorce attorney say, oh, this is okay. I know immediately they didn't consult a real estate attorney. Okay.
Yeah.
Because if I put it in that perspective to a client that calls me and say, hey, my divorce attorney is saying I should give up ownership of my house, but not require a refinance, I would say, look, your divorce attorney doesn't know what he's doing because you're stuck with this loan for the next 30 years. Anything can happen in 30 years. All right. You get married, you want to buy a house, something, you're stuck on this loan. There's nothing forcing your other spouse to agree to a refinance, right? They may not even qualify for a refinance, right?
Correct.
Now,
and then in which case you just sell it and split the proceeds.
Yeah, exactly. Ultimately, the result is still going to be the same. Is if there's a dispute between you and your ex-spouse, the property has to be sold anyways, right? So you end up in that same situation. All right. There's another thing that I want to point out is what I've seen a lot of people like they agree to what is written in the MSA, and then the divorce attorney says, "Oh, I'm done." Right? Divorce has been finalized. When it comes to real estate, just because you've agree to split certain assets in the marital settlement agreement, that doesn't mean it reflects automatically on title. Oftentimes,
Correct.
what I've seen is that people have gone through a divorce, but they never actually sign a new deed or sign or notarize a quitclaim deed transferring that ownership, right?
Correct.
So when it
Yeah.
comes time for them to sell the house, the title company goes, your ex-spouse is still on title here.
I have actually seen that.
See? Exactly.
I'm not even an attorney, and I've actually experienced that because it was, and then they're now scrambling to find the ex-spouse and then remove them. And then if that ex-spouse is not cooperative, woo, good luck.
Yes, exactly. I've actually got numerous calls about that because they assume that, oh, I signed a marital settlement agreement, then this is property is my own. Oh, no. That document doesn't get recorded in the title. That's
No.
not a legal title document, right? There's
Yeah.
no deed. He never signed and notarized the deed transferring the ownership. So on title at the county recorder's office, it's still owned by both parties. All right.
Correct.
So I've
Yeah.
seen that happen way too many times, and this is what happens when they rely on their divorce attorney that doesn't have experience with real estate, and they end up in this situation where now they have a house that they can't sell because they can't find where their spouse is, or ex-spouse is, and
Or their
they can't
ex-spouse just
close
refused
escrow.
to play.
Yeah.
Then you now have to take legal actions to get your ex-spouse to like sign
Yeah.
the quit claim deed because they're not
Correct.
willing to
So that's why
cooperate.
you really have to, even after you agree on the marital settlement agreement, follow through. All right. You got to follow through with the correct documents to finalize this so that on title, that property is yours. All right. And you can sell it freely, not having to get someone else's signature to sell. Right. The cleanest way is really to refinance the loan and quit claim deed to the spouse that is going to receive the property. Even more clean is going to be just agreeing to sell the property and split the proceeds.
Yeah, correct. Yeah, split the proceeds. Whatever's left, you pay off the bank. It's less tricky. It's just
That's
less
tricky.
tricky.
Yeah, it's much cleaner. Now I know people are like, well, I want to keep this property, which is fine. Keep the property, but understand you got to be able to afford the property, right? And this is
Yeah.
oftentimes what dictates how this property is going to be resolved in a divorce is actually the finances involved, right?
Yeah.
Who can afford the house, right? Who has the income that can pay the mortgage by themselves, right? And who can. Now, there's always going to be a discussion about alimony and child support. Maybe that can subsidize some of the mortgage payments, but generally, if this house was bought based on both incomes to qualify, right, you're not going to be able to afford the house on a single income. That house is going to get sold.
Yeah, correct. And then that becomes a whole different problem that we could talk about in a different episode about selling a house in the middle of a divorce. Okay,
That's
so
your job. You have to work with both spouses who are fighting. Nice.
yeah, so I'm gonna play this other video real quick. It's kind of touches on the same point that we talked about. I just thought that this video was kind of interesting, so I just wanted to share it. Give me 1 second. So, all right.
Spouse keeps the house, does the other spouse have to buy? If one spouse keeps the house, does the other spouse have to buy them out, buy their equity out? Does that put them in a situation where then, they can't afford that payment? Or, if they both are willing to sell and get that equity, does that put them in a better financial situation? Can they eliminate some debt? And then what do they qualify for moving forward? And I think it's tricky too, because you're a lot of times in divorce situations, you're going from two incomes and one household, set of expenses. And then now we're dividing and we're having to have two households of expenses.
So this is basically what you and I just talked about, right?
Right.
About there are so many instances of like details that you really need to be aware of. And so it's really important that the person that is in the middle of getting a divorce really understands the full picture. So with
absolutely.
that, go ahead.
No. I think they need to have a full picture and I understand because I work with a lot of divorce attorneys. I get brought, as mentioned, I get brought in to really specialize in how to resolve real estate disputes in a divorce. Okay. Truth be told, there's so many components, especially with child custody and visitation and all the components of a divorce, right? The real estate component often is, lower priority, right? The husband is often, fighting over the kids, um, you know, but it is something that's really important to really figure out. And people will bend over backwards to try to save a house, especially with a low interest rate. I've been contacted by so many. How do I save this house? How do I save this house? I'm like,
Yeah.
can you afford this house? That's the first question. Okay. I
Yeah.
understand you have a low interest rate. I understand, you're in a great school district. I get that. All right. But unfortunately, you're going through a divorce. All right. Right. And saving this house means, can you afford this house? Can you afford the mortgage? Can you afford the property taxes? Can you afford the repairs and maintenance? All right.
Yep.
Because in a divorce and after a divorce, that doesn't mean you have your ex-spouse there pitching in for all these expenses, right? You
Yeah.
are now the sole owner of this house. You're going to be solely responsible for it financially. All right. And if the
Yep.
answer is no, I can't afford it, sell it, split the equity, right? You get that
Yeah.
pot of money, and potentially you can go buy a house with that pot of money that then get a loan by yourself, right?
Yeah.
And that house will be solely yours, right?
Yeah. And the thing is,
And
if
that's
you
just how
fight to keep the house, also, guys, I want you to remember, if you're fighting to keep the house, what could also happen is you may not even have the money to buy your spouse out of the equity that's left in the house.
right.
And at that point, you're taking on all of this unnecessary debt and liability to yourself, that could
Right. So
potentially put
I've
you
seen
in.
some people get into really dire financial situations just to, so you mentioned buyout, right? Let's say we have a property that's worth $500,000. You have about $100,000 in equity. These are just simplified numbers, right? Technically, the equity is split 50-50, right? 50% to you, 50% to the spouse, right? That means if you wanted to solely own it, you got to pay your spouse $50,000. Now, unless you have $50,000 lying around that you're able to pay the other side for, you may actually have to borrow that money, which means not only do you have to sustain a mortgage payment by yourself, you also have to borrow $50,000, which again adds another layer of expenses to you that you got to pay off. So
And that's
it really
and that's a
puts
yeah, I agree.
someone in a very stressful financial situation.
Yeah.
And ultimately, that's why most of the divorces that I've seen, my recommendation is, look, just sell the house, right? There's nothing wrong
Yeah.
with it. I understand that life happens, and you don't want to get into more of a headache trying to save this house.
Yep. So now I'm going to go same type of topic, but not married individual, right? So
Okay.
what happens? What happened? Because there are a lot of people that buy homes when they're not married to the other person, but they think it's a good idea, and they're like, oh, you know what? Let's just buy a house together, right? So I want to share with you guys this real quick, and basically what it is who gets the home when a couple is unmarried and then they split up? What happens there, Eric?
Well, here I'm going to contextualize this for your viewers. All right. This has been, I guess maybe this is a newer generational thing, right? Marriage, or at least legally getting married, isn't a thing anymore. At least all the younger people do these living together, but not actually get married. And I've seen that more and more people have called me where they are boyfriend and girlfriend, they bought a house, then 2 months later, they say, we got to break up. We can't stand each other. And what do we do with this house? Okay. And ultimately, there's really not going to be a lot of options for them, right? it's very similar to what happens in a divorce, but without the whole protections under divorce, like I was mentioning, community property and separate property, right? When you co-own a house, not married, the law essentially treats you as business co-owners, okay? Basically business partners in this house, okay? And your options are either to buy out the other person or sell the house. And if none of those options are agreeable to anyone that co-owns this house, you actually have to file a lawsuit. And this lawsuit is actually called a partition action. And this partition action is essentially asking the court to say, hey, we can't get to an agreement on what to do with this house. We need a court order to basically sell well, it's called partition because in the old days, it was land that could be partitioned out. So if you bought land jointly, the court can basically partition the land, say we can split. But with a house, you can't split the house. So the other option that the judge is left with is basically court ordering the house get sold. All right. So if you buy a house with your significant other and you are not legally married, two options is to buy out the other person or sell the house. That's basically it. There's really no other options to that.
Yeah. I mean, it's basically kind of similar, but the legal mechanisms are a little bit different.
The legal mechanism is you're not going through a family court judge that ultimately looks at the family situation in whole. You're going through a civil judge that treats this situation as a business dissolution, meaning we've created a business to buy this house together, and now we're dissolving that business relationship and we're just splitting whatever equity is that. Okay. What complicates a lot of these partition actions ultimately is because there was never any agreement, and this is something that I want to discuss more, never agreement written down on how to split equity in this property or clarifying ownership percentage, right? Because what happens is I get calls from people that end up in this situation. Oh, well, I paid all the mortgage, or I paid all the property taxes, so I should, and I should get more of the equity. It doesn't matter. Again, the law defaults to 50-50. Okay, unless there's other things in writing. Now, why I bring up in writing, okay? And this is very important. If you do choose to buy real estate with a significant other, okay, it is important that you get something called a tenancy in common agreement or a joint tenancy agreement, okay? It's called tenancy in common because when you buy a property co-owned, you can hold title as tenants in common, or you can hold title as joint tenancy. I'm not going to discuss exactly what those means, or we can defer that to a later episode. But essentially, these agreements detail, one, the percentage of ownership, how mortgage is going to be paid, repairs, expensive, property taxes are going to be split, and more importantly, how is this real estate going to get dispersed, or what's going to happen to real estate in the event we break up or something happens, right? That document is essentially akin to like a prenup or postnup that a married couple is. That document is going to be what the court defers to in terms of resolving a real estate dispute if it happens between you and your co-owner or significant other. All right.
Yeah. Can I interject here real quick? Now, I see this happening all the time too as a real estate agent and broker, is when your client, and this is to the agents out there, and I'm giving you guys a little bit of advice, professional advice, which is when you're helping represent your clients buy a property and they reach the stage in which they have to figure out how to take title to the property, I've seen agents offer advice to their clients about whether it's joint tenancy, tenants in common. Like, do not do that, because what you're doing is you're practicing law, and you can get yourself into a world of trouble as a real estate agent if you're not a licensed attorney when you do that, because you don't fully understand the ramifications of that. And for the viewers who are thinking about buying or selling their home, make sure that you don't ask your real estate agent that question, because they're not qualified to answer that question. Like when I have my clients ask me, how should I take title and how should I take tenancy? My answer is, you need to talk to Eric, right? And so this is, again, why you and I work really well together, is because I hire you as part of the transaction at no cost to my clients when we look and purchase a home, because this is part of the thing that is really, really critical. But so many agents take it upon themselves to represent their clients, not just in a real estate representation, but a legal representation. Would you agree with me, Eric?
Absolutely. Yeah. Taking title is there. And I get this question all the time when people come and say, I got this vesting form from title. What am I supposed to do with it? What am I supposed to select? What is the right answer is always what should I do? Right. What you should do is very situational for your own specific situation. Right.
Correct.
Now, there's different how you take titles. There may be implications on taxes, who gets ownership in terms of someone dying. There's a lot of different situations. If you've been through a divorce, have other kids that you want to make sure this kids gets left with property, how you select title is going to impact that, right?
Yes.
So there isn't a wrong answer or a wrong answer. The answer is going to be what works for you and what your plans are with this property, right? And that's why when agents start saying, oh, no, just check this box, right? You're not really going into the situation in depth to fully understand what the needs of the clients are in order to, make an educated selection on that, right? You're just advising them to fill out this form so you could close escrow, right? And that's why what Scott does is really brings me in, and basically I let the client know, look, these are the differences with each way of how you hold title. It's very situational. What are your long-term plans with this property, right? And then we go from there and saying, whether it's community property right of survivorship, whether joint tenancy is correct, right? But it's a very situational thing that is client specific.
Yeah. And the thing is, Eric, like in states like New York and some of the East Coast states that are foreclosure states, they bring in an attorney on every real estate purchase. It's more of the West Coast states that don't require an attorney to be brought in to review all of these paperwork. And don't get me wrong, NAR and CAR has made it really, really simple to fill out paperwork, right? But there's so many nuances of it that I think people underestimate. And this is why it's really important, guys that are watching, and ladies, you have to work with an experienced, qualified agent who then helps you by bringing in an attorney. And so often, I run into people that says, hey, Scott, I have another agent that's willing to represent me as a buyer, and they're willing to give me all the commissions except, a $5,000 flat fee or a 1%. And I'm like, good luck, because chances are that person isn't going to bring in somebody like Eric to help you and pay for it. So,
yeah. So I definitely agree. This is one area. You bring up a good point. On the East Coast, they use closing attorneys. Closing attorneys are essentially the same as escrow companies.
Oh, so the lawyers are not there to protect you necessarily.
No. I mean, there is that component too, just because they are an attorney and they will, they're basically, but they're there essentially to facilitate. They're a neutral party, supposedly. Okay. And they close the transaction. It's actually, what I've seen is literally they go to the law firm house and they do the whole exchange it's basically like escrow, right?
Yep.
But they do dot the I's and cross the T's from an attorney's form. West Coast says we're in a escrow closing state. Okay, most transactions don't involve attorneys, though they should.
They should. They really, really should.
Right. But I have my speculation as to why, but I won't get into it. But yes, California doesn't require attorneys to close escrow or close a real estate transaction.
Yeah. And it's not just California. A lot of the Western states are like that.
a lot of the Western states, and my suspicion is that the lobby groups in California, like the CAR, they really push legislation to streamline transactions, right? Attorneys, and I mentioned this attorneys are transaction killers, right? We're always looking for reasons why this should not close, or this is a problem that needs to be resolved. We need to delay escrow. We're not getting the information we need, right? Agents are, we got to close this. I need my commission. Okay, so
Hey, I'm not like that, Eric.
Okay, you're not like that. I'm just making a point that it's a very commission-based system, right? Because you guys are only getting paid if it closes. So what that incentivizes is streamlining the process, right? The forms are all there. You just got to fill it out. You send everything through DocuSign and just and sign, right? And that creates problems. That does create, and I've seen problems occur, especially like on title, where you have like misspelled names, you have the deed that's not written correctly, you have certain things that's missed. The hope is that the lender or escrow or title is gonna figure this out. But if not, I've had clients contact me like 3 years after the transaction, they realized the deed that they received had a incorrect spelling of their name.
Ooh.
That's actually a pretty big problem, because now technically on title, it's the name that's misspelled, right? And you got to go through another process to correct the deed, and that's through the county. And it's just another headache that's to remedy the situation, right?
Yeah.
So, so that's right. But anyways, getting back to the original point is that, look, I get it that we're in a new age where real estate is expensive and everyone wants to buy a house, and that's resulted in a lot of boyfriends and girlfriends or significant others, partners, non-married couples buying houses. What people need to understand is the risk involved with it. All right. While you may be all googly-eyed over buying a house with your significant other on the day of, 10 years down the road, that not might be the case. 6 months down the road, that might not be the case. All right.
Or in that marriage, 3 months.
Or 3 months. Okay. Things happen, and you got to understand, because I get these calls all the time, and they're always like, what can I do? Well, I'm an attorney and I have my tools that I can use. My tools are fairly limited because that's what the legal system gives me to use. I can write letters. Okay, threatening letters saying I'm going to sue you if you don't sell this house, or I can file a lawsuit. Okay, those are essentially what I have as my tools to resolve a situation like that, right?
Yeah.
Outside of that, and just like how doctors like preventative care, if you had found me before you actually said I'm going to buy a house with my significant, I could have told you, look, these are the risks of you doing so, and if you're going to do it, please make sure you do X, A, B, and C. Right? Have a written, right?
Yep.
Right. At
It's
least
a contingency planning. Is all it is. Like, if it falls apart, what are we going to do? And are we both willing to agree to it now and sign?
That's risk mitigation. I'm in the risk mitigation business, and people need to understand that you go through anything in life, there's going to be risk, right? How do I minimize this risk? One of the ways to minimize is very simple: get everything in writing, right? If I'm buying this house, look, let's sit down. How are we going to split the utilities? How are we going to split the mortgage payments? How are we going to, because there's no family law institution that protect, because I'm not legally married, right?
Yeah.
In a marriage, if one spouse pays for all of this, the other spouse still gets 50%. In a non-marital status, you don't have family court to figure all this out. You have civil court, which then doesn't treat you as a married couple, right? Yep. So it adds a layer of risk, and one of the risks is if a dispute happens, it can get very costly.
Yep.
Right. So my general advice is, usually if you're going to buy real estate, get married beforehand. If not, at least get like a tenancy in common or a cohabitation agreement or a joint tenancy agreement, something just detailing, all right, this is what we have agreed to. It's a little weird to do that with your significant other. I understand that, but that's just how it's going to have to be done to make sure there's no disputes moving forward.
Yeah. If you're going to buy a house with somebody that you're not married to, a friend, a girlfriend, a boyfriend, a partner, whatever it is, talk to an attorney, because there's so many avenues. And not just talk to like an attorney, but an attorney that actually understands all of this from a legal real estate perspective, because these assets will come back and haunt you. And then we can even talk about going into, on another episode, maybe buying rental properties with partners, because that's also a very
Oh,
common.
don't do it. Don't do it. Don't do it.
Don't do it. Don't do it.
Why are you adding more risk to your life? This is why I said my job is risk mitigation. I have to when a client approaches me and says, this is what I plan to do, I got to use my experience in this area, all the past how many years I've done this, to advise the clients, look, you do this, here's what could happen. This is the worst case scenario. If you're willing to accept the worst case scenario, please proceed. All right.
Well, the thing is there are risk mitigation that you can put in place to protect yourself, Eric. So
Yes,
I
yeah.
wouldn't say don't do it. I just say do it with advice.
Do it with advice. Absolutely. All right. Absolutely,
Yeah.
with advice. But again, people go into real estate investments to make money, right?
Correct.
Any dispute over real estate can really sink someone's cash flow or whatever they've invested in, right, in
Yep.
real estate. So
Yeah.
that's just ways to avoid, or at least get in writing to know that this asset is going to be sold when one person is unhappy with what we've invested in, right? And it's the same thing. Like, you don't have to put this in just a significant other or partner relation or romantic partner situation. Like, if I buy real estate with you, Scott, absolutely, we're going to have something in writing detailing the terms, right, of our relationship, on what happens, and included in those, if there's a dispute, this is how we're going to resolve it, right? Everyone's on the same page. House gets sold, equity split this way, right?
Yeah.
Done.
Correct. And there's a lot more nuances that we could even go into. So if you're planning on buying investment properties, work with an agent that can help guide you through it, like myself, because I can walk you through a lot of different scenarios. It's basically making sure you look at all the possibilities of what could go wrong, and then we go from there. And then you can structure the entity, if you're planning on buying it in an LLC or whatever. You can structure it in such a way that if something did go wrong, there's a solution for it.
Okay,
Yeah,
yeah, we can definitely save that for you. We can definitely delve into what I think about forming LLCs in a later episode. All right, I actually take a very different view on what the industry recommends. Everyone is LLC happy these days for some reason. It's like, I gotta have 5, each one for my condo that I have. I'm like, why? Okay.
Well, the thing is, you have LLCs for your units.
I don't have an LLC for every single unit.
True.
That makes no
I'm
sense.
not saying that that's the case, but if you're buying multiple properties with partners, setting up an LLC makes sense.
Risk mitigation. Okay,
Yeah.
risk mitigation. This is it's a tool to minimize risk. There are other less costly or less hassle ways to mitigate risk. Okay, but we can talk about that in another episode.
General
Right?
partnerships and things like that. Yes, I know.
This issue of everyone needs an LLC is driving me crazy, because I think that's just marketing again for attorneys to sell them, or LegalZoom to sell them incorporation packages. But
yeah, I mean, we can go on. And the thing is, in the state of California, having an LLC is not necessarily a great thing, because regardless, you got to pay that $800 a year fee to California, to the Franchise Tax Board. Yeah, I'm with you. It's just additional cost if you don't need it. So, all right, guys. Yeah. If you guys have any other questions, leave it in the chat below. Send us an email. Follow up with us. We'll get back to you. You can also schedule we're going to drop a banner for you to reach out to me. If you just want to schedule a call, you can go to this website here, findyourhomesandiego.com/contact. You can contact me and I'd be happy to answer any questions you guys have. Thanks very much. Thank you, Eric, for, again, giving us great advice, because I think there's so much here. And the truth is, what we talked today is just a general overview. You need to talk to an attorney. You need to call your own attorney. If you need an attorney like Eric, reach out to me. I'll be happy to put you in touch with Eric for your specific needs, right? I'll see you guys
Yes, Scott.
in a couple of weeks.
Thank you, guys. See you.
Bye.
Bye.